Well, good evening, folks. Good to see you this evening, and welcome to the first of our policy impact seminars. So I'm Pastor Tim Menser. I am assistant to the bishop for discipleship and leadership engagement for the Southern Ohio Synod, and I also work with the Authentic Diversity, Inclusion, and Justice team here of the Synod. And these policy impact seminars are the brainchild of that group. We initiated this idea because we want to provide what we're saying is a measured, rational, and non-reactive look at the impact of certain public policies that are having an impact on our nation. And the group is doing that because we believe that as God's people, it is possible for us to have a faithful and civil and respectful conversation about difficult topics. And so that's the approach that we're going to take tonight and the upcoming seminars as well. The format that we will follow is a 45-minute presentation that looks at a particular topic, and then we'll allow 10 to 15 minutes of questions. We do ask that you submit those questions through the chat so that we have them in writing, and then I can ask our presenter those questions when we get to that point. You should also know that we are recording the presentation component so that we can make that available on social media if you want to listen to it again, because of all the brilliant and wise words coming from Pastor Abrams in a few minutes here. But second, to make that available for people who couldn't join us. The recording will end when we get to the question and answer section. So tonight's theme is looking at the Obergefell versus Hodges case related to same-sex marriage and whether the Supreme Court will take that up. Next month on November 4th at 7 p.m., we'll have Mary Campbell from Amparo through our national church, which Amparo is the organization whose title means accompanying migrants with protection, advocacy, representation, opportunities. And we'll take a look at current public policies and the impact on immigration. And then in January, our hope is to be able to provide an impact seminar on the ongoing impact of federal cuts on social services, in particular Lutheran social services for Central Ohio. But tonight, what is really cool is that we have someone in-house who can actually lead this policy impact seminar, which is my colleague, Pastor Bob Abrams. And so I am, without further ado, going to turn that over to him. And whoops. So that he can take over and get his slides up. All right, Pastor, let's take
I
it.
am apparently the host now.
Yes.
Good evening, everyone. I am going to, if I can see it, hold on just a second. I need to get that toolbar out of the way. There we go. Tonight, we're going to be looking at the case from 2015 of the United States Supreme Court that found a federal constitutional right for same-gender couples to get married. Part of the reason that we're looking at this is the current composition of the court, some sounds being made about revisiting the decision. So what I would like to do tonight is go back to school a bit to talk about the structure of the legal system in the United States, how we got to where the Obergefell case was decided, and some possible implications for what a reversal could mean or could look like. But let me begin by saying this. I'm going to be presenting tonight from a legal perspective, not from an emotional perspective. And what that means is that I'm going to poke at some of the concepts that are at play from the Supreme Court's decision. And at points, you might hear me editorializing a little bit about the weakness of a particular position that the court took or in the dissents. But this does not telegraph anything about my own personal views. I'm coming at it from a legal perspective. Um, and so let's get started with a little bit of my background, just so that you know that I'm not making this up out of thin air. Um, I was I am a former attorney. I was admitted to the Ohio bar in 1993. I've got to move this. Hold on just a second. Okay. I was admitted to the bar of Ohio in 1993. I'm a graduate of the Ohio State University College of Law. Um, Go Bucks. I am currently registered as inactive. What that means is that I'm a member of the bar, but I am not permitted to practice law. I am not permitted to give legal advice. I am permitted to give legal information. So I'm not going to be able to answer specific questions tonight about anyone's particular situation. Um, I am a former assistant county prosecuting attorney, a former assistant Ohio attorney general, and a former litigation manager and uh, attorney for a property casualty insurance company. In all, I practiced about 16 years. My undergrad, and this is going to reveal maybe a little too much about me. My undergrad was focused in constitutional and legal history, both in the United States and in the United Kingdom. And then I'd like to tell people that Jesus ruined my legal career and God won. I was ordained in 2011 and I have not looked back. I am where I am called to be. However, I do have some ability to discuss the issues at hand in the Obergefell case tonight. And so we thought that might be a good place for me to go. So I have to give you, by law, I am required to give you a disclaimer. I am not a licensed attorney. Specific legal questions should be directed to a qualified and licensed attorney. Today's presentation is for informational purposes only. My goals tonight in the presentation are these. Refresh us in our knowledge of how the federal system works in the United States. There are many federal systems across the world. Everyone is a little bit different. The United States federal system is quite different, for example, than the German federal system. So we're going to talk about how it works here. We are going to trace the roots of the primary legal doctrine that led to the Obergefell decision in 2015 and why it is controversial in some quarters. We're going to explain the two primary schools of constitutional interpretation that are at work on the United States Supreme Court today. We're going to look at whether Obergefell is vulnerable to reversal, given the current composition of the court, and possible implications of a reversal if that were to take place, and possible remedies. So let's go back to the schoolroom for just a bit. The United States is not what's called a unitary state or a unitary government, meaning that we have both state governments and federal government. We are the United Kingdom, for example, is what's called a unitary state that has devolution now, but the United States is different in the way we are structured. Remember from history that the states existed prior to the federal government. The states called the Constitutional Convention to form a stronger national government. Before that, it was the Articles of Confederation, which didn't work very well. the United States was too weak on the world stage with that system. And so they called a constitutional convention, and then they adopted the constitution that was proposed. And that happened in 1789. What I would like for you to remember tonight is that the states agreed in the Constitution to delegate some of their sovereign powers to the federal government, but not all of them. So there is a perception often that exists that the federal government is the big government and the states are under the federal government. That is not true in most circumstances. There are circumstances where it is true, but in most circumstances, it is not true. Today, if you look at all of the laws that exist in the United States, and I think that the number I saw was about 700,000 different laws. Only about 5 to 10% of all of the laws and regulations in the United States are federal. The rest are state and local. That means that you and I are in our daily lives mostly governed by state and local law. That is something to keep in mind because it impacts us far more than federal law. However, if the federal government does have authority to legislate or act in an area, the federal legislation controls. So if the federal government can act, its law is supreme. But most of the time, it cannot. So what are some examples of the exclusive federal powers that were given in the Constitutional Convention, in the United States Constitution, I should say? For example, coining money. States are not permitted to print or coin money. It used to be able to, but when the Constitution was adopted, that power was taken away. They are not permitted to regulate international trade and relations. That is a federal power. Uniform bankruptcy system was given to the federal government. It used to be that each state had its own bankruptcy system. That was taken away from them or given by them to the federal government. So now there is a national system. States cannot declare war or wage war. The federal government has the power to regulate interstate commerce. The federal government has the power to protect intellectual property rights like copyright and patent law. All of those are listed powers. Anything that is not enumerated in the Constitution or implied by it, all other powers are reserved to the states or to the people. Make sense? So understand that at a basic level, marriage and divorce laws remain largely powers that are reserved to the states. The federal government has to have the specific ability to intervene based upon a constitutional provision. It doesn't have a general power to legislate on what marriage is or is not. Now, what are the limits on federal power and now on state power? Well, the first limits that were enacted, other than what I just described for you, were the first 10 amendments to the Constitution. We know those as the Bill of Rights. I am going to review those tonight because there are 2 amendments that are specifically applicable here, but I want to go through them so that you remember what the government can't do in our basic Bill of Rights. So, under the First Amendment, we have freedom of speech, assembly, religion, and the press. The federal government originally was the only one affected by the Bill of Rights. Most people don't know that, but it says that Congress shall make no law abridging the freedom of speech. Later, it became applicable to the states. But freedom of speech, assembly, religion, and the press, so that militias can be raised. Those are volunteer armies of citizens. The right to bear arms shall not be infringed. No soldiers can be put in your house without your consent. What that means is in the old days, in the colonial days, the colonial government could put soldiers in your house and say you must feed them and give them a bed That right was taken away from the government in the Third Amendment. The Fourth Amendment, no unreasonable searches or seizures and warrants issued by a court must be based upon probable cause and list specific locations, people, and things being sought. Now, I want you to pay attention to this one. There's a lot packed into the Fifth Amendment, but it says, first of all, you cannot be convicted of a felony in federal court unless you have been indicted by a grand jury or you have waived that right. So you have the right to a grand jury for felonies. You cannot be tried twice for the same offense. You cannot be compelled to testify against yourself. Remember the Miranda rights that we see on TV. You have the right to remain silent. Anything you can and say will be used against you. That comes from the Fifth Amendment. You have the right to due process. So you cannot be deprived of life, liberty, or property without due process of law. We're going to take a really close look at that in a little bit. We are all given the right in the federal system to equal protection of the laws. And the government cannot take your property, meaning your real estate or your personal property, without paying you for it. That's in the Fifth Amendment. The Seventh Amendment, we're jumping over the Sixth, by the way. The Seventh Amendment, federal court, you have the right to, believe it or not, this is a perfect example of why never to put a specific number in a constitutional provision. If the amount in controversy is over $20, you have a right to a jury trial in a civil case in federal court. The Sixth Amendment, by the way, has to deal with the right to counsel when you are accused of a crime and being tried. You have a right to an attorney. The Eighth Amendment prohibits excessive bail or cruel or unusual punishments. This one, by the way, and I'm going to say this straight up in case there's a question later, the Ninth Amendment says the listing of these rights is not exhaustive, but the Supreme Court has never defined what that means in 235 years. They have never defined the Ninth Amendment. And lastly, the 10th Amendment, at least for right now, powers not given to the federal government are reserved to the states or to the people. Okay? So the federal government has a lot of restrictions on it, and it can only act in certain areas. However, there was a major shift in power that came after the Civil War. And in 1866 and 1867 and 8, what happened was amendments were adopted to address the issues that led to the Civil War. Slavery and its impact on society. So what happened is that these amendments began then to apply the rights that I just described for you to the states. So state governments can't deprive you of these things. Let me give you an example. The First Amendment says you cannot establish a religion. The federal government cannot have an established religion. But there was no constitutional provision that stopped state governments from doing that. And in fact, there were established state churches up until the 1830s. Congregationalism was the state religion of Massachusetts until the 1830s. So the Civil War changed all of that. But we need to look at these amendments just so that you know what they are, because the 14th Amendment is what has led us to today with the Obergefell. I keep saying it backwards. Obergefell case. The 13th Amendment abolished slavery or involuntary servitude in the United States, except as a punishment for a crime. So when you see prisoners picking up litter along a highway, they're not doing that because they want to. They are being forced into labor. It's controversial today, but that is the reason they can, except as punishment for a crime. This is the big one. This is the one I want you to pay attention to. And a lot of stuff is happening right now in the news that comes right out of this amendment. The first paragraph of the 14th Amendment says, if you were born here, you are a citizen. Why was this adopted? Because of a case that the Supreme Court decided that we're going to talk about in a few moments that said that that enslaved people or anyone of African descent could not be citizens of the United States because it was never contemplated. The 14th Amendment said anyone born here is a citizen. Secondly, this is the biggie. States are now prohibited from depriving their citizens of life, liberty, or property without due process of law. The states are also prohibited of depriving persons of the equal protection of the laws. So it tracks the Fifth Amendment, if you remember what we said about the Fifth Amendment. Same language. It also, in its last paragraph, prohibits anyone guilty of insurrection against the United States from holding public office. The 15th Amendment forbids the states to deprive a person of the right to vote on the basis of race or previous condition of servitude. By the way, that amendment was adopted in 1868, I believe, but this right was not fully realized until 1964 under the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And that's because the Supreme Court was, I'm going to say this, I'm editorializing, was complicit with Jim Crow South in how it interpreted this amendment. So, what process is due? So when we say no state shall deprive a person of life, liberty, or property without due process of law, well, what's due process of law? That's the question. If they can deprive you of life, liberty, or property with due process, what are you entitled to? Well, when the amendments were adopted, this was a very narrow concept. And what it meant was this: you could not be jailed or imprisoned or have your property taken away or be executed unless you had a fair hearing before a neutral judge. That's what it means. That's what it meant. So the due process was notice, I'm using the legal definition here, notice and an opportunity to be heard. You get notice of the procedure that's being brought against you and an opportunity to speak and defend yourself. Fair procedure. However, so let's see, let me move something over here. I'm going to bring something up that's very controversial, but and I'm going to get to it in a second. But starting in 1857, the Supreme Court started down a road where they said that certain rights are implied in the Constitution and that no amount of procedure was enough for the government to take them away. So the question was, what are those rights and who gets to decide what they are? This doctrine, this concept became known, and this is the key phrase for tonight. It's known as substantive due process. And it is an oxymoron because process can't, in the law, never can be substantive. It's procedure. But the Supreme Court has adopted a doctrine called substantive due process. And a lot of the rights that you and I exercise today are based in this doctrine. And it is a controversial doctrine. So let's talk about it. It is the crux of the decision in the Obergefell case before the Supreme Court that led to the right to same-sex marriage. So what are some examples? This is a warning. What the first example is not only controversial, but it's painful. The first example where this doctrine showed up in some form was in a case called Dred Scott versus Sanford. Now, I'm going to preface this by saying this is the position by many jurists, but not all. Some say that Dred Scott wasn't a substantive due process case, but Chief Justice Roberts, in his dissent in Obergefell, said it was. Um, I will say, at least in my opinion, the elements of substantive due process are there. But what was that case? Congress had passed a law saying that no slavery could exist in the United States above the state of Missouri, so that physical line. Um, the Supreme Court held that there was an implied right to own enslaved people. And not only that, because of that, Congress had no power to legislate on the issue and take away that right. And therefore, the Missouri Compromise of 1850, which set that line, was unconstitutional. It was this decision, Dred Scott, was not overruled by the Supreme Court. It was overruled by the Civil War and the 13th Amendment, which abolished slavery, and the 14th Amendment, which gave formerly enslaved people citizenship. Not largely, generally, and considered to be the worst decision ever decided by the United States Supreme Court. But it's not just that. In 1905, the next time substantive due process shows up is when this is the progressive era, when states and the federal government, in some cases, started legislating around working conditions. New York passed a law that set maximum hours for bakery workers and other workers. The Supreme Court of the United States held that there was an implied liberty interest in the due process clause of the 14th Amendment that allowed factory owners to enter into contracts with their workers for as many hours as the owners needed. And they struck down New York's wage and hour law as unconstitutional. Then, during the New Deal, several big New Deal programs were invalidated by the Supreme Court under the substantive due process doctrine. So when substantive due process first showed up, friends, it was actually used in a way that we would generally recognize that it hurt people, not helped people. And the people who decided what the rights were unelected judges. So there was much criticism of it. So much so that Franklin Roosevelt, President of the United States in 1937, threatened to pack the US Supreme Court with a new justice for every justice over 70 in order to get past it. That was substantive due process being applied. And the Supreme Court had an epiphany suddenly, and one of their justices changed their vote. And in West Coast Hotel versus Parrish, the Supreme Court held that no, there is no such thing as substantive due process. So do you see why this is a controversial doctrine? We'll get to the liberties later, but that is where it started. There's one outlying case that I'm going to bring up. Oregon used in the 20s passed a statute that said there will be no private schools of any kind, parochial or any other kind. The Supreme Court used substantive due process to strike that down, saying that parents had a liberty interest in their children's education and upbringing. So Oregon statute was struck down there. Now, here's where we start to see Obergefell, the roots of Obergefell showing up. First, in 1965, so we're talking from 1937 to 1965, there was a general assumption that this doctrine didn't work. It doesn't exist. Connecticut had a statute that outlawed anyone from using contraception. Connecticut's position was they wanted to promote procreation. So a challenge was brought to the statute, and in 1965, the Supreme Court used substantive due process in finding what's called the right to privacy, and said that they are invading a person's life in that way, what took away a liberty interest that the government had no basis taking away, even with the right procedure. That Griswold case, the dissent in that case, and I remember this from law school, one of the justices who dissented said, "This is an uncommonly silly law, but it's not unconstitutional." However, the majority found that it was unconstitutional. The Griswold case became the basis of later decisions that were more famous. However, in 1967, substantive due process was found there was a liberty interest in being married. This has a direct bearing on Obergefell. The Supreme Court struck down a Virginia statute that forbade interracial marriage. Then, in 1973, relying on Griswold and relying on Loving versus Virginia, the Supreme Court used the doctrine of substantive due process and that privacy right to find that there was a right to abortion that states could not infringe on until a certain development of the fetus. We all know how controversial that topic has been in the last few years, mostly because the Supreme Court in the Dobbs case from 2022 overruled it. And what the court held was there is no national right, there is no federal constitutional right to abortion. So they reversed themselves. But let's keep going until we get to Obergefell. In 1990, the court held that the liberty interest of the 14th Amendment meant that if a person had articulated their wishes prior to becoming in a vegetative state or in a terminal condition but can't communicate, that they have a right for their life-sustaining treatment to end. That was the Cruzan versus Missouri Department of Health case. That, friends, is where durable power of attorneys for healthcare came from, the Cruzan case. In fact, I was in law school at the time, and I remember the State Bar Association rushing to get forms out for people to use for this new right to withhold life-sustaining treatment or demand the withholding. Now, this is one that there was a reversal, a flip on this. I'm going to start at the last sentence. In 1986, a man was arrested in Georgia. They were serving a search warrant in a hotel room. He was engaged in sexual relations with another man. He was charged under Georgia's sodomy statute with sodomy and convicted. He challenged his conviction in federal court. It got to the U.S. Supreme Court, and in Bowers versus Hardwick, the court held that there is no liberty interest at play that is recognized in the Constitution, and therefore his conviction would stand. Meaning, they actually said these words, there is no federal right to homosexual sodomy. Those are the words they used. That was then reversed in 2003 in Lawrence versus Texas. And the same justice that wrote the opinion in Lawrence versus Texas wrote Obergefell. That's Justice Kennedy. And what the court did in Lawrence versus Texas was hold that there was a liberty interest in private consensual sexual relations among adults, and that people have the right to be let alone. That phrase was used, and that was found in the Due Process Clause of the 14th Amendment. Then, in 2015, the question was, are same-sex or same-gender couples entitled under the federal Constitution to be married in any state based upon the federal right? The Supreme Court held, yes, there is a federal right to same-gender, same-sex marriage, and it used much of the same reasoning as Lawrence versus Texas, but it went further. But it was based primarily in the Due Process Clause of the 14th Amendment. So substantive due process was the primary basis. Now, I'm going to go in that a little bit deeper because it becomes very, very important about what happens later. The question is, what's the problem with all of this? The problem is that there are two major schools of thought on how you interpret a constitution. And depending on what school of thought you're from, the outcomes change. The first school of thought is known as textualism and or originalism. And what that means is this: any right that is asserted or anything asserted about the Constitution needs to have a textual basis. No one is contending, for example, that the United States Constitution says people have a right to marry regardless of gender. It doesn't say that. In fact, the Constitution doesn't mention marriage at all. Textualists would say that matters. They would say if you're going to assert a right, it needs to be found in the text or in a principle from the text. And then you tag that to originalism. And what that means is, well, how do you know what the text means? What you look at are the principles that were agreed when it was originally adopted. So you're looking at a snapshot in time and then the principles. So for example, if you are talking about the right to, let's see, what would be a good example? The right to engage in interracial marriage, an originalist would say you have the right to marry under state law, but the government has no power at the federal level to interfere with what that means. It's a little bit complicated, but what I will say is this: textualism and originalism, the argument in favor of it is it takes away much of the power of unelected judges to decide new concepts. Then you have the folks on the other side of the coin, and those are the living Constitution people or the progressives. Their view is that the Constitution must be a living and breathing document, and it must keep up with the times, and that if we don't do that, then the Constitution will become unworkable. And so rights need to be found based upon the context of today. The downside of that argument is who gets to decide what the rights are? 9 unelected justices of the Supreme Court. And a downside of that also is that because this living Constitution approach really took root in the 60s primarily, the court has become much more politicized because of in the appointment process, because now they start having litmus tests for what the judges think. Before that, it was almost non-controversial to appoint a Supreme Court justice. So there are downsides and benefits to both sides. I guess that is what I'm getting at. Um, that is what is at issue in Obergefell and in many other cases. So let's talk about the case at hand. So what happened? Jim Obergefell and John Arthur were legally married in Maryland. Maryland allowed same-sex marriage, but then they moved to Ohio. Arthur died, and Jim sought to have his name listed as the surviving spouse on the death certificate. Now, there are a lot of other cases attached to this case, but this is the primary case. Ohio had a state constitutional ban on gay marriage or anything approximating it. And so the request to be listed as the surviving spouse was denied. And by the way, in case you're curious, that ban on gay marriage is still in the Ohio Constitution. It's just unenforceable. So Jim brought suit to compel Ohio to list him as the surviving spouse and to invalidate Ohio's ban on gay marriage as a violation of the 14th Amendment. He lost at the district court, the federal district court, and then he lost at the Sixth Circuit Court of Appeals, which covers Ohio and Tennessee and Kentucky and Michigan. So he appealed to the U.S. Supreme Court. And here's what happened. It was a 5-4 vote. So it was a divided Supreme Court, and the court held this. Number one, marriage is a fundamental liberty interest in the U.S. Constitution, and it is therefore protected under the Due Process Clause of the 14th Amendment. This was their primary basis. What do I mean by the Due Process Clause? You cannot be deprived of life, liberty, or property without due process of law. And we're talking about substantive due process. So Ohio, nobody contended that Ohio didn't follow its proper procedure in adopting the law. It's what they were arguing was that Ohio had no right to even pass the law. So the court, citing Loving versus Virginia, stated that there is a right to marriage, and that right included of same-gender couples, same-sex couples. The court, in adopting, in voting this way in the Obergefell case, overruled itself, Baker versus Nelson from 1972. Now, this is important too. The Equal Protection Clause of the 14th Amendment, the court held, also bars states from prohibiting same-sex marriage. This is a problem in my view. They didn't do an equal protection analysis. There's an analysis that you do for substantive due process, and there's an analysis that you do for equal protection. They did not do the equal protection analysis. They really relied on substantive due process, which is more controversial. The court held that all couples should have equal dignity in the eyes of the law and receive the benefits associated with marriage. They found that the right to choice in marriage is inherent in the concept of individual autonomy. It's fundamental. It supports a union like no other institution. And it helps children and families, which brings up the rights of child rearing, education, and procreation. Marriage is the keystone, they found, of our social order. So, bottom line, the majority opinion draws on this living constitution idea of constitutional interpretation rather than originalism or textualism. But since that time, the majority of the people on the court now are originalists or textualists. I'm going to kind of move through these because I don't want to keep you here too late. Chief Justice Roberts wrote a very important dissent. He said, same-sex marriage may be a good policy and a fair policy, but the Constitution doesn't address it at all, and the court has no power then to force the states to accept it. So, textualism. It's a matter for the voters and the legislatures to decide. And then he said this, The courts can only declare what the law is, not what it should be. He rejects living constitution. And then he said, there's no textual basis in the Constitution for the decision. Justice Scalia, who got a lot more colorful in his language the closer he got to his death, said this is nothing more than a raw exercise of judicial power based upon the personal values and opinions of 5 unelected Supreme Court justices. It's not based on the text of the Constitution itself. Justice Thomas, I'm not going to go deep into this. I want to point out an irony, though. Justice Thomas argued that marriage rights and licenses are government constructs, not fundamental rights. But Justice Thomas, if I may say so, lives in Virginia and is a Black man married to a white woman. Therefore, in his analysis, he would not be permitted to do that in Virginia. Religious liberty is implicated by this decision, he said. Think the cake baker cases. Remember the cake bakers? And then he said this, human dignity isn't granted or taken away by the government. But all the dissents question the use of the substantive due process doctrine. Here's the kicker, friends. In Justice Thomas wrote in 2022, when they overruled Roe versus Wade, he specifically invited the court to revisit Obergefell as being wrongly decided. So how can it get up to the court now? Anybody recognize that picture? Kim Davis. She refused to issue a license despite being ordered to by a federal judge after the Obergefell case. She was held in contempt, put in jail. Then she was sued by a gay couple for refusing to do it, and a federal jury awarded them damages and attorney fees. She appealed to the Sixth Circuit, which rejected her appeal. She has now sought review by the United States Supreme Court, and it is pending. That request is pending. I want you to know that I checked their order list today, and they have not ruled yet. It only takes 4 justices to agree for a case to be heard, not 5. So, what would happen if Obergefell was overruled? This is the law. If the Supreme Court finds that it was wrong in the way it interpreted the Constitution, that case is treated as if it was never the law. So the overruled case was never the law. And so the new ruling would automatically be retroactive. Do you see the implications of this? Because marriage law is mostly a state issue, if Obergefell would be overruled, a retroactive decision would almost certainly mean that same-sex marriages conducted in states where there are bans would be invalid. The marriages conducted in states where it was permitted would still be valid. Now, I'm going to say that, but then I'm going to say this. There may be a mechanism for the court to bypass this. So any decision would have to be read closely to see if how the court addresses that question in its ruling. There are 3 things that caution the court against, though, overruling. First, the doctrine of stare decisis. Anybody hear of this? It is the presumption that once a court decides an issue, all parties after that need to be treated the same way and who are in the same situation. It does not prohibit a court from overruling itself, but it cautions a court. Now, obviously, in the Dobbs case, it did overrule Roe versus Wade. The biggest one that's at play here, and I want you to remember this one, is called the doctrine of reliance. If citizens rely on a decision in the organizing and living of their lives, The court tends to shy away from reversing itself because it affects people who relied on the decision. Now, this is a factual statement, legal statement, not an emotional statement. Pregnancy lasts 9 months, more or less. Because of that, the time frame goes up and down quickly compared to how legal cases are decided. It was not as much of a reliance interest to overrule Roe, but it would be a big problem to overrule Obergefell because over 1 million people now rely on it for parenting rights, inheritance rights that come from marriage, tax benefits, property ownership, on and on. So the reliance interest, in my view, would become a big issue before the court if it were to take this up. Lastly, the more the court reverses itself, the less credible it becomes. Chief Justice Roberts is known to be keen to protect the court's institutional role as a stable arbiter of disputes and of interpretation. In fact, in the Dobbs case, he did not want to overrule Roe. He wanted to simply uphold the 15-week ban because he thought overruling Roe would lead to discrediting the court. So it is by no means certain that Obergefell will be overturned. It is possible. It's not certain. If you are concerned about your own marriage, consider seeing an attorney who specializes in family law to protect your rights as much as possible. There are mechanisms that can approximate marriage rights that an attorney can help you with. And remember, many states, including Ohio, have ballot initiatives that can change the state constitution or laws by popular vote. Are there any questions?
And a reminder, if you want to submit a question, to do that through the chat. I am looking, oh, I can't stop the recording. Pastor Abrams, if you could stop the recording. It's always dangerous to give Pastor Abrams power, but he has power right now. So I want to thank you for the way you unpacked how the process has evolved over time and how we got to where we are, and also what will be considered in the time coming up. Any of you have questions you want to ask?
I'm going to offer an opinion.
You have an opinion? No way.
I have an opinion. What I will say is this. My view, my personal view, is that the court would be far better off to do a full equal protection analysis because an equal protection clause finding is textually rooted in the Constitution, more rooted in the Constitution. So if they are asked to review this, if they can go in that direction, that might be a different outcome and a more solid outcome than the current situation.
So, Pastor Abrams, one of the questions we have is, do you think there will be a request for an emergency ruling on the case?
I don't think so. And the reason I don't think so is that we're talking about a money damages judgment. And when there's an appeal, typically what happens is that the money damages judgment is stayed pending appeal. So there's no emergency.
Okay, thank you.
Did they do a equal protection clause? Is that what you just said?
Yeah,
Did they do that for Virginia, Loving versus Virginia?
they did not. And I take that back. It was primarily rooted in the liberty interest argument. I'd have to look back and see if they did an equal protection analysis. I do not understand why it was not done primarily based on equal protection.
Okay.
Now, understand something. Equal protection analysis is very complicated because the question is, are you similarly situated? And does it involve, are you part of what's called a suspect class? So in order to do that, the court would have to find that gay and lesbian people are a suspect class, which they have never done. I told Pastor Tim this beforehand. My view is that if they can bring evidence that sexual orientation is an immutable trait from a scientific perspective, then I think you have a really solid argument that it is a suspect class. That's why I think they should go down that road. But who am I? I'm just a guy sitting here in Columbus, Ohio.
Now, when you say suspect class, not as in that something is.
Mm-mm. What it does, if you're a member of a suspect class, so what they found as suspect class is race, religion, um, national origin, that kind of thing. It raises what's called the level of scrutiny. So a law would have to be narrowly tailored to the government's interest and not infringe on other rights. And it's very hard to pass that strict. It's called strict scrutiny. If you get to a point of if it is not that, if you're not a member of a suspect class, it's just a rational basis. The law just has to have a rational basis, and that's a very low standard. So in order to do this analysis, they would have to really dive into what sexual orientation is, and I just don't think they either don't have the record in front of them to do that with expert testimony. But to me, that would be a far more stable finding than substantive due process. Nope, nobody thinks equal protection is controversial. A lot of people think substantive process is controversial.
Is there anything states can do right now to protect? I don't know if Ohio would do it, but like states that allowed marriage to happen before to protect it, like codify it or something. Is there anything states can do?
I mean, the most that the most that people can do, that a state could do, is make it legal. Because if it's legal now, it will be legal if there's a reversal. Now, can a state make it retroactively legal? Probably not. Maybe, but probably not. Um, that complicates a lot of other things to do it that way. Um, so I think there's some vulnerability. I do think there's vulnerability if they take the case up. Although I'm going to add this. I heard I don't know how true it is, but then on the news, there was a report that Justice Alito, who's one of the real textualists, one of the real conservatives, stated that he essentially it was settled law and he didn't want to revisit it. I happen to think that Chief Justice Roberts, I think Kavanaugh, I think Coney Barrett, I think that they would not necessarily be interested in going back on this one. I think Justice Thomas has made it very clear that he does want to go back on it. So I think that there would be some swing votes here that were not at play in Dobbs.
Great. Well, I have 8 o'clock, so we're ending right on schedule. Thank you, Pastor Abrams, for time you spent preparing this and presenting it such a clear way that led us to where we are right now. It's really helpful. Would the slides be available to send to people if they requested them?
Yes, as long as you don't hold them out as legal advice to someone.
Okay. So if you would like a copy of the slides, you know, send us an email and we will forward them to you because it's very helpful to have that because it's a lot of good stuff in there. So I appreciate that. And Jane, you're talking, but you're muted. So if you want to There we
Okay.
go.
Yeah, I'm here tonight instead of being at our Equity and Justice Committee meeting. So I'm the only one from the committee here, and I'd like the rest of them to see this. So
We can both do that, and we'll let you know when the recording is also available.
okay, thank you.
I want to hear that as well. So, well, thank you all for joining us tonight and helping us with this new endeavor for the Synod. I'm thankful for our Authentic Diversity, Inclusion, and Justice team who are responsible for saying, let's go ahead and run with this idea. And thank you, Pastor Abrams, for a job well done. Appreciate that. You all have a good night now, and take care. And we'll see you in a month, hopefully.
Yes.
All right, take care.
Bye,
So long.
thanks.
Bye.
Uh-huh.